Good afternoon to all of you out there. It's a pleasure to be with you again. It's August 9th and it is hot here in New York City. There was never a doubt as I left my apartment this morning that we are in August. It's supposed to get to the mid 90s today, potentially. Small anecdote about how hot it is. My son, who's in summer camp before school starts up again, that camp's ending early because they don't want to be out in the heat as things get tough during the middle of the day. So in the middle of your August, wherever you find yourselves, let me walk you through what we intend to cover today. So Kathy, if you would please advance to the next slide, I'll happily do that. So here's the agenda for today. Thank you, Kathy. First, we're going to be covering what typically I will run through. It includes our public health relating updates on COVID, of course, and I'll also touch on new and emerging challenges that certainly we should all be tracking. And I'll also add a touch of coverage on federal legislative activity. There's been some big stuff happening in Washington over the last couple of days. Then I'll turn over to Giuseppe Franzella, who's back with us from Melville. And he's going to cover a really interesting dynamic concerning Twitter and Elon Musk and some implications concerning contract law that he'll highlight. I'll speak again after Giuseppe. I'm going to talk about the healthcare and mental hygiene worker bonus program, which for many of those listening, we know is something you've been waiting to hear about in terms of how it will all work. It went live fairly recently. September 2nd is the first deadline, which is certainly not so far from now. So we'll go through all of that. Sandra Casey is back with us as well out of our Albany office. And she'll provide an update of federal Title IV regulations. Then I will answer any questions at the end that you might have posed and we haven't had a chance to address. So stand by for that. And with nothing further, Kathy, here, let's go to the next slide, please. And we'll get into the details of where we are on COVID. And so in specific, what we would really love to know is whether this is going to get better or worse. And the reality is we just don't know. Right now, we're looking at a 16% drop, which is great news. The last time I was here with you, we had seen 2 successive rounds of 2-week intervals of essentially, roughly 20% hikes. And this is in the national picture. So we're in this ebbing and flowing that I've described before, and it's about learning to live with the virus. Next slide, please. The hotspots are comparatively reduced because, of course, when you have a 16% or so drop nationally, you're not going to see as much intensity on the map. And so I just compared the left and right sides of these slides for your edification as well, because I think it shows us that, again, we're dealing with a relative calm, but we're still very much in the midst of a pandemic, given the kinds of infection we're still seeing. Next slide, please. In New York State, we are also seeing about a 16% change in positivity. That drop is considerable, of course, because in New York, we were following trends of much of the country. When last I spoke with you at the end of July, we were noticing that there was some relative lessening of the rate of infection in New York relative to the country, but we were still seeing more than we had before. It seems like we have hit a peak and now we're on our way down, though, again, we just don't know because we're all living this together for the first time. And we'll continue to track it closely, but nothing has changed from the regulatory standpoint, whether in New York City, where I'm speaking with you from, or otherwise across the state. Let's go to the next slide, please, if you would, Kathy. And if you look at the 2-week differentials by county in New York State, you'll see Much of the counties arrayed there are down. There are a couple that are up, whether Warren, for instance, or Sullivan, but you'll notice that essentially there are in those fairly small sample sizes, and so there's some volatility in those numbers that's different from some of the larger areas like New York City, where you don't see those kinds of jumps in quite the same way. So again, the big picture in New York is that we're a bit down in this 2-week period. Next slide, please. Now, last I spoke with you, we addressed monkeypox for the first time, and we received a number of queries from listeners. Can we learn a little bit more about it? And certainly, it seems like we all are learning more about it now, because we've moved from where we were 2 weeks ago, where the WHO declared the global health emergency, to now, if you go to the next slide, please, we have seen, thank you, Kathy, a real change on the ground in terms of the governmental response. And we have, of course, the Biden-Harris administration declaring a federal public health emergency relative to monkeypox. You can look to Section 319, as noted on the slide. New York City and other jurisdictions, including New York State, are also elevating the urgency, through their own emergency declarations. And here are the stakes. As we heard from our mayor here, Eric Adams, roughly 150,000 people are potentially at risk in the city alone in terms of likelihood of infection. And so this is a certainly growing challenge for our public health systems writ large. And we are continuing to track, of course, as it relates to all of you, the implications for your businesses. And at this moment, what we can tell you is this is still developing. And we do know that expedited resources are going to really try to halt wherever possible, or at least slow down the considerable community spread, as well to get those vaccines where they need to be. That is a bit of a challenge right now, both due to supply chain issues and the current volume of vaccines available. There's some interesting scholarship that I happened to notice in the New York Times over the weekend around essentially some studies around splitting vaccines and the relative efficacy. All this is happening because we just don't have enough right now as it relates to monkeypox. This is not the first time the world has encountered monkeypox. It's just the first time in a while that we have seen it at this kind of volume. And so government entities are gearing up. Why don't we go to the next slide, please? And if that weren't enough, unfortunately, I'm reporting out to you that polio is also a challenge for us, not to the same volume, as far as we know, thank goodness, and vaccination rates around polio generally are much higher, and that has a direct effect on spread. But there are some counties where those rates are lower in the lower Hudson Valley, particularly on the western side of the Hudson, and there is evidence of community spread that the state health department is certainly watching closely, and we'll keep track on, of all of that for all of you. Why don't we move to the next slide, please? So with a bit of a shift in topic, I'm moving away in part from public health and just to talk about, bigger picture issues that, certainly will affect all of us depending on how this all advances. Over the weekend, we saw significant movement, including the Senate passing the Inflation Reduction Act of 2022. This is really substantial legislation. There was uncertainty whether it would ultimately get through the Senate, in part because of what was a party line vote involving Vice President Harris in her tie-breaking role. And also because Senators Manchin and Sinema had not initially made clear whether they were going to support the legislation, including through its various iterations that no doubt you've been following. But this has now passed the Senate, hasn't passed the House yet. That's important to note. It will get before the House floor, we expect, around August 12th, when the House recess concludes. And if it does clear the House, which is likely given the relatively greater Democratic majority there, it seems to be a foregone conclusion that President Biden would sign it into law. And so let's talk about what this bill, if ultimately passed, or rather signed into law, would do. It is really significant when it comes to climate change, including about $27 billion in greenhouse gas reduction funding. There are attributes of it that touch on prescription drug pricing, including in the Medicare program, prohibitions around whether essentially negotiation is permitted around drug pricing in the Medicare program have been in this legislation broadly lifted. And so there's a lot here that we'll be tracking, particularly because no doubt the healthcare and environmental components alone will, as they advance, have implications on your business practices. And so we're making sure that you know this is coming down the pike potentially, and we'll keep you updated as we learn more. So with that, Kathy, if you please would advance to the next slide. What I'll do now is introduce Giuseppe Franzella more formally. He's a member in our Melville office, back speaking with us. He has been on our program before. You may remember that Giuseppe is part of Bond's combination with Laser, which essentially gave us the entire team in that Melville office, and we're grateful that they have brought their tools and resources to our clients. So in this collective form, Giuseppe was a partner at Laser, and in his work, he is very much a litigator focused on all phases, including discovery, pleadings, motions, appeals, trials. And what he's here to talk to you a bit about is specific performance and the case against Elon Musk. And so, Giuseppe, I look forward to learning your perspective on this. It should be pretty interesting, and the floor is yours.
Thank you, Gabe, for the kind introduction, and thank you all for sticking around to hear my part of the presentation. You've probably been made aware by now that Elon Musk, who previously offered to purchase Twitter, is now seeking to back out of the deal. And Twitter has sued Elon Musk in Delaware Chancery Court. As of this recording, the latest and greatest is that Elon Musk has filed a counterclaim against Twitter. So how did we get here? Well, several months ago, Elon Musk made a fairly terse and pretty straightforward offer to buy Twitter. It's long been reported that Elon Musk has found Twitter to be something of a virtual public square. And in essence, if you see the slide, his last sentence, and again, of what is a fairly terse offer letter, is that Twitter has extraordinary potential and that he will unlock it. And so Elon Musk has reportedly had this notion that he is the person that can effectively save Twitter and return it to something of the public square that he believes it should be and can be. The issue for Twitter is they didn't necessarily initially want to be purchased by Elon Musk, but they were sitting on a share price of approximately $50 per share. Elon Musk offered $54 per share, and when soliciting potential other offers, no offers came close, and so therefore they were forced into position, Twitter that was, of considering the Musk offer. And here's where it's relevant to other corporations and business entities. Twitter is, much like thousands and thousands of corporations, LLCs across the country, a Delaware-based entity. Delaware is famously favorable to corporations. Its corporate governance laws are favorable to business entities, and therefore the proposed purchase agreement. In the proposed purchase agreement, the parties consented to jurisdiction from the Delaware Chancery Court. Kathy, if you could please advance it to the next slide. Thank you. And the Delaware Chancery Court has a long historical history of dealing with corporate governance disputes, mergers and acquisitions disputes, and therefore it was the perfect venue for jurisdiction over the purchase agreement between Twitter and Elon Musk. So Elon Musk, and it's been pretty widely reported that there's very little that he negotiated in terms of due diligence in his offer to purchase Twitter. And among the clauses in the agreement is a financing clause, and therefore there's a clause that would allow Mr. Musk to back out if indeed he didn't secure financing. However, he did secure financing, and he secured financing pretty early. And where the deal has come to somewhat of a halt is in disclosure, and specifically with respect to bots. Now, Elon Musk has indicated that he believes Twitter is not giving him the proper disclosures and is in fact underreporting the amount of bots or fake users that Twitter has. And bots are something that is not unfamiliar to Mr. Musk. When he tweets, he gets hundreds, if not thousands, of bots that respond to his particular tweets, and so he's intimately familiar with bots. Twitter has reportedly opened a fire hose of disclosure to Mr. Musk, and so Mr. Musk has essentially threatened to back out of the deal, indicating that the product he offered to purchase is not what indeed it was purported to be, and it's something widely different. Now, there's some practical reasons for not necessarily believing this theory of the case, and that instead, much like other tech stocks, and specifically tech stocks that are advertising dependent as Twitter is, the value has gone down for the shares of Twitter since Mr. Musk made his offer. One of the reasons for that is for a good portion of that time, the news has been pretty bad. So advertisers don't necessarily want to be advertising their products above, say, a negative report about the war in Ukraine. And so tech stocks for some period of time during the period that the parties have been negotiating have been depressed as a result of things like bad news and things of that nature. So in a cynical way, you could view this as Elon Musk trying to renegotiate the deal. At the moment, there are really three options here. And there are three options because what Twitter has sued Elon Musk for is specific performance. Now, specific performance is a fairly common provision in an agreement such as this for a merger and acquisition. And in fact, the Delaware Chancery Court has some historical precedent for insisting that a party move forward with a merger and acquisition and ruling and directing that they specifically perform the contract. So the three options here are specific performance, in which case the Delaware Chancery Court would order Musk to perform the contract. Now, that's something that parties on either side of a merger and acquisition could be concerned about, or something they should be aware of in their agreements, is whether specific performance is something that can be upheld, notwithstanding a potential change in the nature of the dialogue or the nature of the negotiations. And here, again, there wasn't really an out for Mr. Musk for something like this, where, for example, he's alleging that there were too many bots or not enough actual users of the product. Another option is that the parties could simply renegotiate, that this is a ploy for Mr. Musk to try to renegotiate the purchase price. And the third is that the court direct Mr. Musk to pay, or the parties settle on a payment of what is a $1 billion termination fee that's in the agreement. But again, the specific performance clause, and Kathy, I'm sorry, if you could please proceed to the next slide. Thank you. Okay. The specific performance clause in this is pretty broad and wide ranging. And it seems as though Twitter has satisfied the elements of specific performance, in that there's an existence of a valid and binding agreement, that Twitter is alleging they complied with the agreement, and they are alleging that Mr. Musk has failed to abide by the agreement. And in the specific performance clause, it allows for specific performance if in the event that Mr. Musk has secured financing, which he has here. Now, Mr. Musk, in turn, is counterclaiming against Twitter and counterclaiming that there has been fraud, and that the fraud is that Twitter misrepresented the amount of actual users. And his counterclaims are also pending before the same court. The Chancery Court has previously deemed other similar events to not be material adverse changes and still directing parties to move forward with mergers and acquisitions under specific performance clause. So there is a real risk to Mr. Musk. Now, one thing that I've found interesting is that there are legal pundits in multiple spheres who have questioned whether the court would direct specific performance because the court might fear that actually compelling specific performance from someone who it can be as volatile as Mr. Musk might be difficult. And my concern there in response is that seems to be a somewhat dangerous precedent if the court fashions a result out of fear of not being able to compel Mr. Musk to abide by the law, and setting up a scenario where litigants can argue, why should there be a different system of justice for someone who is in the public space and notoriously volatile as opposed to any other corporation or business entity? So the court does have a fairly public balancing act to undergo. And the problem for Twitter now is that they almost need to go forward with the deal, because in negotiating the deal in public, Mr. Musk has essentially depressed the product. He's suggesting to advertisers that the amount of users to whom they are actually advertising their product is far less, that Twitter is a product that features many bots. And the issue with this, just from a purely public-facing perspective, is in some ways, this is the problem that Mr. Musk, part of the problem that Mr. Musk claimed he was going to come in to cure. So the way that will shape out will be very interesting. It certainly could go any of these three ways, and it could be something that resolves itself pretty quickly, or given that it's playing out in Delaware Chancery Court, we might have to wait until 2023 or beyond before we actually get an answer. Kathy, if you could move to the next slide. Forgive me. So thank you everyone for engaging with me on this discussion, and again, keep your eyes on the news to see how this all plays out.
Giuseppe, that was really fascinating. Appreciate your perspective. And for all of us who gather information through various means, some of us use Twitter a whole lot, I'm sure, including those here. To be clear, not an endorsement. That is up to you. But certainly it's a part of the way news is exchanged. And so we'll be keeping our eyes on it. So why don't we move to the next slide, please, because I am back with you. And let me tell you a bit about healthcare and mental hygiene and this worker bonus program. As I highlighted earlier, it's open now. And the first major deadline is September 2nd of next month, which is not so long from now. And this is a big deal for those of you who practice with your businesses in and around the healthcare environment. We know that involves many of you. Let's go to the next slide, please. So the origins of this program essentially are from within the state budget approved in the spring, and there was language concerning healthcare worker bonuses embedded within there. But it has taken some months to essentially make operational how to move that approximately $1 billion set aside for so-called frontline healthcare worker bonuses. The expectation would be that eligible individuals would be able to receive about $3,000 each in total. And as we move into the mechanics of this, we're seeing that play out as envisioned, with about 1,500, excuse me, per vesting period. We'll talk more about what those vesting periods look like. And in total, the eligible individuals are quite numerous. And we'll discuss some of the individuals who are carved in and those who might unexpectedly be carved out as we progress here. One big qualifier is that the frontline workers envisioned here are those generally making $125,000 at a capped amount or less, but that excludes bonuses and overtime. And the role, again, really matters quite a bit in terms of who's eligible. So let's move on and get a little deeper, please, Kathy. So the eligibility for these bonuses extends to generally those individuals who were employed at the appropriate times in terms of these vesting periods, with organizations that have linkages to the Medicaid programs of New York State, some aligned other programs outside of Medicaid that are carved in specific ways that we can get into the weeds on with you, if you will, in follow-up, because there are nuances here and they're considerable. For instance, one might not think on face that fellows and residents are included, but they are. And that's at the Commissioner of Health's discretion. That involves many of our education clients, particularly those that have a foothold in medicine generally. And so the timing of the bonus payments is also something we want to highlight for you. For those employers that partake in this program, and we expect that will be many of you, you must essentially take the funds that you've received and then pay them out no later than 30 days after receiving funds from the state for that purpose. And there are limitations in terms of employers' ability to opt out. Some might say, for what is $3,000 per employee relative to administrative challenges of implementing this, maybe it doesn't make sense for our organization to go forward. But there are functional restrictions that make it pretty difficult to opt out, namely in terms of measures against the number of eligible individuals that an employer may have or had during the vesting periods anyway within their workforces. There are also attestation requirements that employers will need to both not only pay heed to, but also actively implement, again, for this first round before September 2nd. So there's some work ahead. Next slide, please. And so as far as employees are concerned, as I alluded to earlier, about 6 months of continuous employment, in fact, specifically 6 months of a continuous employment is required over the span of a vesting period. And there are eligibility requirements that are really focused on title. I've provided the URL to the titles, and that's important to look at very closely, because what we have seen in helping bond clients thus far, among colleagues who have reported to me in any respect, in any event, excuse me, is that essentially these titles really do matter, and that those who fall in these titles are eligible, and that those who fall outside of them are not. And so employees will also be subject to attestation requirements of their own. And so essentially there'll be two-sided attestations, all as a means of providing a level of program integrity from the state's perspective. Why don't we move to the next slide, please, Kathy? And so there is a portal which we encourage all of you to take a close look at, which is listed out there. You'll find the URL as well as an FAQ resource. And this DOH portal is essentially where DOH is orienting all activities around these bonus payments. And so that is where much of the public-facing presence around this program will be found. Of course, as noted earlier, it germinates from the budget agreement and the essentially the language that codified that budget. So this is just a manifestation of that language now that we're moving into this operational phase. Let's go to the next slide, please. So as I've mentioned, there are successive phases of this that are going to be opening. And so right now we're in the first, and that is one that closes on September 2nd, and it pertains to work of employees who are eligible during the appropriate vesting period of October 1st of 21 through March 31st of earlier this year. There are going to be other similar vesting periods on a going forward basis with deadlines upcoming in October, May of 23, October of 23, and May of 24, at least as presently envisioned. So let's go to the next slide, please, Kathy. And so I mentioned this portal earlier. No, you don't have a need to navigate the periodic table of the elements, but just in terms of focusing your energy on the elements themselves, I thought it would be worth just highlighting that the portal includes details on what the attestations require, which concern, among other elements, the hours that the employee worked, when those hours were worked, details on essentially monies earned by that individual or individuals during the relevant vesting periods. And so it is a detailed process, and we encourage all of you who expect to interface with it to review that portal material rather closely. And please trust that we here at Bond have already been helping those within our client base that have reached out to us. We're very much here to help any of you on these matters. So let's go to the next slide, and we can talk a little bit more then, please, Kathy, about what we've been hearing and learning thus far in the course of these efforts to both learn more about the program and to advise our clients who have been asking about it. In terms of eligible titles, as I noted earlier, we are pretty confident in this fact that if the title is not on the published list that DOH has put forth and that you'll find on that portal, it's going to be a heavy lift for an individual to be deemed eligible. And so that we recognize could lead to consternation, complications, et cetera, but the list is really important to look at, and the phrasing in terms of the titles matter much. And then this is an important nuance in terms of the treatment of the bonus payments. As far as we can tell, based on, against what some of my colleagues have learned and what I'm reporting out here on our collective behalf, we understand the bonus payment to be part of the regularly hourly rate for the basis of overtime pay calculations. And so if someone worked overtime during the vesting period, as noted here, the employer, we expect, must calculate and pay an additional amount of overtime pay. And then in terms of multi-employer benefit funds here, we recognize that among those listening, we represent and otherwise support employers that contribute to multi-employer benefit funds. And it's very much possible, based on the terms of the CBA or otherwise a contribution agreement, that there may be further payments still required. So it'll be important to essentially understand where those points of interface are, which once again, we can help you with. So why don't we go to the next slide, please? And so I want to highlight as well, please, a few more questions concerning what we have learned and what we want to really leave you with. Again, the eligible employees are based on that roster that you find on the portal, and it really is an important tool to cross-reference. It is further important to mention that the definition of a healthcare worker or a mental hygiene worker really links up to that list of titles. It's specific for this program, and it's important to, again, make those ties. And does your organization have to participate? If your employer wondering that, again, for those administrative headaches and burdens, the short answer is it is advisable that you do. We can talk with you specifically about that. If you have sufficiently numerous employees that ultimately, essentially it may become a challenge if those employees are themselves concerned that they're not being granted access to the program. And there are other details of the program that we understand essentially incent or otherwise direct employers to be participants in it if they do have, again, a cohort of eligible employees who have vested. And so here's another interesting issue that we've heard about, and this is still playing out. We understand, at least in one instance that we've encountered here, that of course it happens across business that there are different types of employment arrangements, and sometimes employees are leased to organizations in a functional fashion or otherwise in more intentional terms. And if there is not a direct and linear employment relationship between one of those employers that is in the Medicaid program or otherwise involved in some of the otherwise supported programs through the terms of this, it may not be possible for those employees to receive their bonuses, which is not per se what was intended from everything we understand, but at the moment that's a hurdle that hasn't yet been overcome. And getting back to how quickly organizations should be moving on this, can't say it enough, September 2nd is right around the corner, and there is a lot of legwork to do for organizations that have employees that have vested during that 6-month period connected to September 2nd. And again, we are here to help in making sure that you complete all of the required materials in order to be compliant. With that, why don't we go to the next slide, please, Kathy? And I'll leave you with a final note concerning the Department of Health. While it doesn't directly relate to the bonus program, it is important that we think about all that the pandemic has brought. And one of the realizations was that the current configuration of the State Department of Health could benefit from reorganization, including that being the belief of the current commissioner. And so just very recently, the Department of Health went forward in a public fashion with a reorganization plan. And there are several new areas of focus, including an Office of Health Equity and Human Rights, an Office of Aging and Long-Term Care, a CMO for the Department of Health, and a commissioner's cabinet, which includes a variety of leaders across the state's public health domain, and an emphasis on strengthening the regional offices, whether the Marrow here in New York City or others around the state. And we shall see how this all unfolds as the state moves to implement these changes. But for those of you who work in and around the healthcare environment, we thought it was important for you to be aware. And with that, I wish to just go to the next slide, please, which is my opportunity to make sure that Sandra Casey, excuse me, has an opportunity to give us a full presentation at the concerning the U.S. Department of Education's Title IV proposed rules. But before we do that, which is what I wanted to just check, is whether there are questions we can answer in real time. I'm seeing a number of them concerning the bonus program that I will work to respond to offline while Sandra is presenting as best I can, and those that we can't, we will certainly follow up with you on. But for now, giving Sandra just a few moments, we're going to be talking about, as I said, Title IV. Sandra is back with us. She is a regular contributor to this webinar. We are really stronger for having her here. She has been a higher education attorney of great accomplishment, including not only at Bond, but before in leadership roles as Deputy and Acting General Counsel for the SUNY system and as College Counsel to Siena College. And Sandra, knowing that we are tight on time, let me please give you the floor and thank you for presenting to this group on this important set of issues.
Thank you, Gabe. Happy to be here and happy to be speaking to you from the higher ed legal corner. And last time I was here, I spoke about the proposed regulations for Title IX, which are very important. And people around the country are paying lots and lots of attention to those proposed regulations for Title IX. But I wanted to shine a little light on Title IV proposed rules that came out. So next slide, Kathy. So there are two sets of proposed federal financial aid regulations that were published in July of this year. Now, I think some schools look at the Title IV regulations and know that they're very skilled and knowledgeable financial aid office has got a handle on them. To me, financial aid directors and staff are rock stars. They're very talented. They're very knowledgeable. But some of the rules that come out of the student aid program impact every aspect of the institution and not just the federal financial aid office. The borrower defense rules is an example of that, which we will talk about. So these regulations were subject to negotiated rulemaking where committees formed by the U.S. Department of Education would have to reach consensus on the rules. So the committees reached consensus on some of the rules that were being proposed, meaning that they had unanimous support, but they didn't reach consensus on all of the rules. So where there's not consensus, the Department of Education is free to create their own rules. And this is what happened in the case of the borrower defense rules, which we'll talk about in a minute. So the comment period for these Title IV rules is very short, only 30 days. And the department is in a rush to finalize the rules before November 1st for an effective date of July 1st, 2023. If the final rules are not published by then, the effective date of the rules would be July 1st, 2024. And this rigid schedule really is a result of the requirements in the Federal Higher Education Act related to student aid provisions under Title IV. It's called the master calendar for people who are interested. Next slide, please. So the comment period for these proposed rules that were issued on July 28th, 2022 ends August 26th, 2022. These rules set forth eligibility requirements for incarcerated individuals to receive Pell Grants and a prison education program. Specifically, the proposed regulation defines incarcerated individual as one who is serving a criminal sentence in a federal, state, or local penitentiary, prison, jail, reformatory, work farm, juvenile justice facility, or other similar correction institution. What's notable about this is that the department added in juvenile justice facility to allow access to those in the juvenile justice system. There is research done that shows that access to education really reduces recidivism, and what better place to have that occur than when someone is in a juvenile justice system. Next slide, please. The proposed rules would also amend what they call the 90-10 requirement for proprietary institutions. Under the Federal Higher Education Act, proprietary institutions are prohibited from deriving more than 90% of their revenue from federal sources, and therefore must receive at least 10% of their revenue from non-federal sources. The proposed rules would specifically would specify what funds should be considered federal funds and provide more regulatory oversight over calculation of federal versus non-federal revenue. The NPRM would also create a new requirement for when proprietary institutions must request and disperse Title IV aid. Next slide, please. The proposed rules also provide greater oversight when there is a change in ownership that moves a proprietary institution from profit making to a nonprofit institution. Specifically, the proposed regulations would clarify the existing definition of nonprofit institution to ensure that institutions converting from proprietary status meet the standards to qualify as a nonprofit, including to avoid providing net earnings of the institution to a private entity or person, establish clear upfront requirements for applications for changes in ownership, and provide for greater clarity in the procedure the department follows in reviewing changes in ownership for continued eligibility for Title IV aid. Next slide, please. So the comment period for the proposed regulations that came out on July 13th is actually this Friday, August 12th. These proposed rules touch upon various requirements in the direct loan program, the federal Perkins loan program, and the federal family education loan program, and provide more favorable treatment to the borrower in terms of discharge of loans due to disability or public loan forgiveness. The Department of Education really felt that there needs to be more access to these programs and relax the rules a little bit for the borrowers. Next slide, please. So really, what I really wanted to focus everybody's attention on were these borrower defense rules. As stated earlier, these rules could not be agreed upon by the negotiated rulemakers. In other words, there was not consensus among those negotiated rulemakers to propose the rules. So therefore, because there was not unanimous consent, the department was free to create their own rules. And so they did. And these proposed regulations are a result of that. So these regulations make really sweeping changes for individuals to apply for discharge of their loans based upon the institution's conduct. Now, the advertising around these rules is such that they target proprietary schools and some of the abusive practices that these proprietary schools had engaged in the past. And it resulted in people being without the education that they sought, and they had tons of debt as a result. So they needed to crack down on school practices. But please know that these rules apply to not-for-profit institutions and the publics equally as they do to proprietary institutions. So it is something that everybody needs to be aware of. So what are they? So a borrower can discharge a loan when the Department of Education determines that an institution engaged in substantial misrepresentations or substantial omissions of fact, breached a loan contract, engaged in aggressive academic recruitment, or was subject to a judgment based on federal or state law in a court or administrative tribunal of competent jurisdiction based upon these behaviors, or were subject to a prior sanction by the U.S. Department of Education. Now, each one of these bases has a lot of layers, and I really can't get into each one. I mean, each one would really require 20 minutes of my time, and we don't have that time here. And again, I just wanted to provide you a very high-level overview. So let me just take an example, although of one, like breach of a loan contract. The regulations don't specify what a loan contract is. They don't define it. And it could be anything from, what's posted on your website, what's in your handbook, your student handbook, and it really would be up to the department to decide that if a person wanted to discharge their loan. So we have to be careful. Like we saw this with the tuition refund cases where courts were looking to see what promises the institutions were making on their website, in their policies, and their, in their advertisements in terms of in-person instruction. So then when they went to online instruction during COVID, did they breach their contract with the student? So that's something to be aware of. Like we have to really look at, what constitutes a contract. And you have to look at all your materials and make sure you're not over-promising things. Another area that's a cause for concern is that if there was a prior sanction by the Department of Education, that could be used against an institution. So for instance, if an institution had a program review and was required to pay a fine, that might be used by a student to try to discharge their loan. So it's really overreaching what the department has done here. Next slide, please. So where the borrower defense is warranted, the proposed regulation would also enhance the department's recoupment authority, making it easier for the department to hold institutions accountable for costs by recouping the cost of discharged loans. So basically, if a loan is discharged, the department can come back to the institution and say, okay, we need to recoup those costs from you because we're not going to be out of pocket. There's also a process in the proposed rules to allow not only individuals to apply for discharge of loans, but also for the department to institute its own action on behalf of an entire group of borrowers to pursue a discharge. Both the individual application and the department's group action would be decided by department staff and not by an impartial hearing officer. So this implicates, due process rights for the institution. The new rules would apply to any borrower defense applications pending on or after July 1st, 2023, without regard to when the conduct upon which the claim is based took place. So thus, past conduct that does not constitute the basis of a discharge now under current regulations could be deemed to violate the law after the new rule becomes effective. So it has like sort of a retroactive impact, which really is not constitutional. So there's also a presumption of the rules that the borrower was harmed by the conduct of the institution's conduct. So the borrower would need not show actual harm. So that's another area where the institution would be limited in its defense against the discharge. Next slide, please.
And I hate to interrupt, Sandra, but we are over time a bit. So if you have just a closing remark or two, we'd appreciate it.
Sure, and we're at the perfect time I'm just concluding that I just wanted again to highlight these Title IV rules. If you have the time this week to review them with your counsel or with your trade associations to comment, please do so. I think it really would behoove all of us if we had many comments from the institutional perspective. So with that, I turn it over to you, Gabe. Thank you for allowing me the opportunity to speak today.
Thank you. And I hope that those who do have that time to review, reach out to Sandra or any other attorney at Bond with whom you work, if you do have questions. And as always, we thank you for taking the time to be with us. We will be back with you in a week's time. Adam will be hosting you then. I'll be back with you in 2 weeks on the 23rd, at which point we'll, I presume, still be talking about some of the issues here, and we'll be highlighting you on what's new. And in the meanwhile, wishing you safety and hoping that you stay cool out there. Thank you for taking the time to be with us today.